The only difficulty is, first of all, I find it as time bar. We are not surplus any application copy or anything. The second difficulty is, I don't know about the object party number one.
There's an application being CRA in number 1 of 2024.
It's on the list, but the state has not served us. So we don't-
See, I already filed the affidavit of service.
1 minute. Whom you are representing?
I am for the petitioner state.
It's a
Lordship.
concept, it's our public process.
So you are representing the respondent number
Object party number two.
2, D. Satish Chandran. What about the opposite party number 1?
Lordship,
Mr. D. Irango is appearing for
You are representing.
Here.
Acha,
Mr. D. Irango.
acha,
I'm the junior of.
acha, You have received the copy of the application?
Yes, sir.
Which application? Seeking condonation of delay. She is not aware.
Inspection.
I am aware, the entire thing has come in one parcel through the SHO of the local police station. But what they've done is given us the CRR, the main, the grand, I'm sure Mr.
Lordship, today itself I can serve, Lordship. If not available, I will serve today. Today I serve,
When it has been filed,
Lordship. Earlier August. But I serve,
So-
Lordship, maybe by mistake, Lordship, my part, I apologize for
no,
that
it is not mistake.
to my part, Lordship. Today itself I will serve,
What you have
Lordship.
been filed,
Lordship,
it served upon
Lordship, today itself,
both the.
both the parties, both the respondent.
Hmm. Mr. Kabir, let it senior counsel.
Mr. Prasad.
Kabir, let it senior counsel, representing the respondent number 2. And your name is,
Mr. D. Irango.
Senior. आपका
he has not come to court.
आपका नाम बताओ.
Your name.
Case name. Case name, junior to Mr. D.
Hearing the provision of
One
slip.
knows everyone.
So it will be up to you all to pick the names. Representing the is representing the respondent number 1. Full stop. The petitioner is being represented by the PP. Public prosecutor. You are the public prosecutor.
Lordship.
Public prosecutor. Full stop. The learned senior counsel submits that there is a delay in filing the instant revision application. The present revision application, instead of instant, the present revision application. And to that effect, an application seeking condonation of delay has been filed, but the respondent number 2 has been served with a copy of the revision application only. While the copy of the application seeking condonation of delay has not been served as yet. Full stop. Your contention is also same. Have you taken instruction?
No, Your Lordship.
um, the the learned public prosecutor submits that during the course of this day, copy of the application being copy of the application seeking condonation of delay being CRAN number 1 of 2024 shall be served upon the learned counsels representing both the respondents. Full stop. Let the matter be taken up on.
But I would request some time to file a reply because this is a 17 month delay. They were discharged last year in October, in 2023 in October or September. The matter has been simply hanging fire. So I would like to place some objection in a week's time. They can come on Monday.
Monday. On Monday. As the lyrics senior counsel representing the respondent number 2 further submits that he intends to file an affidavit in opposition to the said application. I think to that no reply is required.
Lordship.
Let the matter and a week's time is sought for. Full stop. Let the matter appear on the 13th of January 2025.
Right.
Item 2, WPH 718 of 2024.
My lordship, my senior is appearing for writ petitioner. Copy not served. Let the matter may be fixed on Monday.
You are representing the
Writ petitioner.
writ petitioner.
My senior is representing writ petitioner.
What is the impugned order?
Copy
What is
not
the
served.
impugned order?
My lordship,
Oh,
my lordship, my senior
copy
just
not served. From
Just-
the-
inform me. Copy not served and take the
Why,
date.
why?
He is unwell, my lordship.
Deputy Commissioner and the Sub Registrar,
My lordship,
when it can be served?
tomorrow, my lordship.
Hmm?
Tomorrow. Let the matter may fix on Monday, my lordship.
Why tomorrow? Why not tomorrow? Let the matter appear tomorrow.
My lordship.
On
Deeply pleasant.
the company level. The learned counsel, the learned advocate seeks an accommodation for this day. Let the matter appear on 8th of January, 8/1, 2025.
Deeply pleasant.
Item 3, CO 33 of 2024.
Mr. Kripa's ATS for the reason like we put both them up and Kripa start also.
Item 4, CO 48 of 2024.
I'm for the respondents.
All the respondents.
Yes, all the respondents.
Filed by the other side. For petition. Yes.
The file is put for partition.
Suit for partition.
I appeared for the defendants. I filed my written statement, I disclosing that there is a family settlement deed.
You are the plaintiffs.
In the trial court, I am the plaintiff.
Plaintiffs.
So, on the basis of that.
On the basis of
settlement
deed of settlement.
It was between the brothers and sister or the co-sharers. They made a settlement deed registered before the registrar, and the property will be divided in accordance with the settlement deed. We brought into the notice of the court that in the pleadings, they amended their plea. They said that as per the settlement deed, property should be partitioned. Then I filed a petition under order 12 rule 6. There, in total, I admitted their prayer, that they are ready to partition in terms of their prayer made in the plea. That petition filed by myself was rejected by the trial. First, Your Lordship, I will show the plate filed by them. Amended plate starts page 31.
Page 16 is
Page 16 is the original plate.
original print.
And my written statement, page 24, I disclose that the. When they amended their plate, kindly come to amended plate, page 31. And 31 paragraph, especially paragraph page 34, paragraph 11, A page 33.
What had been inserted in the amended plate?
Amended plate, they inserted that as per the settlement deed, property is to be partitioned.
In which paragraph?
A to 11 D E.
E.
11 E, up to 11 E. They inserted this, that as per this is to be done.
11A, 11 B, C, D and E.
Yes, E up to E.
No,
This, as per this is to
the
be
amended
partitioned.
portion is B, C, D and E.
These were the amended, they amended the plate. Subsequently, after getting my written statement and coming settlement deed. They mentioned that as per this is to be done. I admitted that it is to be done as per that, their prayer made in the plate. The trial court rejected my prayer on the ground that they are disputing the settlement deed. Though they are mentioned in their pleadings at the settlement deed partitions to be done. And now they cannot dispute this. Because they are themselves praying to partition as per the settlement deed.
What is the prayer?
Prayer, Lordship, that is page
35.
Page 35, it's got 36.
36.
Criminal decree declaring the plaintiffs have acquired their right title interest over the property by way of inheritance. Past possession of the plaintiff over food property, appointment of partition. Then I filed 12-6 petition, next page, Your Lord. Page 40.
Place the Lord Counsel, we place paragraphs 11, the entire paragraph 11, from 11A to 11E.
Yes.
Okay, let me go through. So the suit has been filed by the wife of Mujibur Rahman
Deceased.
and the
Children.
Children, 3 children, 3 sons.
3 sons.
Yes.
You are the brothers,
And the sisters.
sisters of Mujibur Rahman. Two property is
Same to property.
100. You are aware, but I am not aware.
That is
9255.
page 27.
Three hundred square meters out of total, 300
330
square
square
meter,
meter.
330 square meters out of total area 561 square meters. So 330 meters in survey number 925. 925.
As per the partition deed, this was given, taken by Mujibur Rahman.
So you do not have any claim in respect of 924 by 2,
No, my lord.
only in respect of 925.
95.
In paragraph number 11A, it has been mentioned that 561 square meters in respect of 925. In the schedule of the property, it is mentioned 330 square meters. Why is it so?
So as per the partition deed, he
The
will get
surrender.
more land.
There
As
was
per actually entitlement, he was entitled less land. But as per partition, Mujibur Rahman, he got 330 square meter of land. As I mentioned in para 11C. In their pleadings, 11C.
All the brothers and sisters,
All the brothers.
they are claiming 1/4 share each.
yes, my lord.
No. Here, as per partition deed, he will get 330 square meter. Not less than. So 1/4 is, 1/4 will not come. They are getting more than 1/4.
Hmm.
330 square meter.
According to Mohammedan law.
No, it is because partition deed made between the parties. So personal law will not.
Okay,
prevail.
mutually, amicable
Mutual.
settlement, amicable settlement.
Partition deed registered before the sub-registrar.
Has that been produced or annexed?
And that is
No,
not
ma'am.
next. I will
That is
produce it.
required.
I will produce it tomorrow.
So according to both of you,
Yes.
it has been amicably settled
Yes.
through a
Part-
partition deed.
We are challenging, my lord, we are challenging the partition deed, my lord. Because it's a manufactured document. So we are questioning on that.
Their pleadings not reflecting to that effect. They're challenging that agreement. They are admitting though.
Where is the written
My-
statement? Where is the written statement?
My written statement. I think that is page 24. I have mentioned about this registration of the.
Paragraph 6.
Yes.
This has been filed on
It was filed on 28 January 2020. Till date, it
One
has
minute,
not
one-
been challenged.
one
More
minute,
than
one
2 years
minute, one
back.
minute, 1 minute, council. Item number 3. Item number 4. CO 58. WS filed on
28 January 2020.
28 January 2020. So it is a, through paragraph 6, you have stated so.
Paragraph 6, paragraph 12. I am stating these facts. And after
Paragraph 6 and paragraph 12.
12. After getting this, they amended their claim.
Step by step. You are acquainted with the list. The court is not acquainted. The court will have to be acquainted
Yes.
with the list. So originally the property belonged to late Hamida Bibi,
Yes.
Yes, mother of the.
mother of yours.
Deceased
Mujibur Rahman and defendants.
So, so 925, survey number 925, area 561 square meters.
Yes.
And 925 by 2 is area 130 square meters. The plaintiffs are not concerned with 925 by 2, 924 by 2.
No,
Why not?
by way of act, my lord, by way of inheritance, my lord, it's only the Mujibur Rahman late, he was married, solemnized second marriage, Your Honor. So, Your Honor, as per the by way of inheritance, they are entitled, respondent number 1, respondent number 2, 3, 4, they are only entitled for the limited shares, Your Honor, which is 330, and we have paid for such shares only, according to a schedule of property.
What bars them from the other property?
Your Honor, because my lord, we are challenging the partition deed, my lord, because late Mujibur Rahman was a habitual drunkard person.
So,
So the documentation
so
is
you are
manufactured.
challenging the partition deed.
Yes, my
So
lord.
it was within your knowledge.
No, my lord. Once the written statement was filed, my lord, then only it came into the knowledge, and after that the amended plaint was put forth before the trial court.
Prior to that,
No, my lord.
1 minute, prior to that, why didn't you claim in respect of 925/4? 925,
My
survey
lord,
number 925?
we're not in the knowledge, my lord. Only after the written statement we came into the knowledge, but then also, my lord, we are not claiming for that.
So amended petition, amended plaint, paragraph, page number
34.
34.
31, start from 31.
31. No, take off.
33.
The program for the customer of during the lifetime of the multiple element of the execution of the partition date. And it's only disclosed. The document is not disclosed the building, but the document wherein you have challenged, through which paragraph you have challenged the contention of the,
My lord, in the amendment state, file amended plaint, we have not challenged on that ground. But my lord, in order 12 rule 6, we have put forth our objection, written objection, my lord. And which clearly states in there.
when have you filed the written, filed the amended plaint?
18 January 2022.
So written statement has been filed on 28th January 2020.
Yes.
Amended plaint, considering the written statement, has been filed on 18th January 2022. That is after 2 years. And therein you have not challenged the contention of the defendants.
It's matter of trial.
So now what is the impugned order?
Page 49.
Application order 12 rule 6 civil procedure code in page 40.
Order in favor is page 50, 49 after 49.
No.
Order.
No. Petition is page 40.
Page 40.
Written objection is page 46.
46.
Are there any other heirs of Mujibur Rahman?
So that is the plaintiff number 2, 3 and 4.
Only three.
Apart from
No, ma'am.
1, 2, 3 and 4? No.
No, ma'am.
She is the first wife of
Yes,
Mujibur
ma'am.
Rahman.
Yes, ma'am.
What about and the plaintiffs number 2, 3 and 4 are the legal heirs
Of the late
of,
Mujibur
of
Rahman.
late Mujibur Rahman,
From the first.
born from the
First.
first
Yes,
wedlock.
ma'am.
As regards any other further wedlock of Mujibur
She was
Rahman?
made party in the
Hmm?
play.
Hmm?
She was second wife was made party in the play. So subsequently they deleted her name.
Subsequently deleted.
Defendant number 4.
1 minute. How can it be dependent number 4?
Defendant number 4.
Salma Bibi is the second wife of Mujibur Rahman.
But dependent number 4. Salma Bibi. Her name has been deleted.
Yes, they filed a petition under order 110.
She's not a necessary party, so it was deleted by law.
Though the first wife is not entitled to inherit any property because she married twice to a third person. That is.
It is denied. The same is also
Order
denied,
1
my
rule,
lord.
order 1 rule 10(2) was allowed.
Hello.
Yes, my lord.
So that if
I'm not representing her.
Hmm?
I'm not representing her. 1, 2 and 3 I am representing sisters.
was it served upon the
She is not party
dependent-
now.
What a-
prior to that
Yes, she was served.
she was served.
Yes,
She had represented.
No.
I think she was not. represented.
The plaintiff number 1 has married again. Not only again and again.
Yes.
No. May I submit, my lord?
Let me go through
Yes.
the impugned order. The registered deed is dated 5/9/2011.
Yes, madam.
You have filed a written objection to
Order 12, rule 6.
Order 12, Rule
Yes,
6,
my lord.
wherein you have admitted
My lord,
that the plaintiff number 1 was the wife of Mujibur Rahman and during his lifetime she was divorced.
yes, my lord. And from the said wedlock, there are 2 and 3 who were born.
So the impugned order says that no decree on admission to be passed in
Yes,
this suit. Because there is no unanimity of opinion regarding the partition deed alleged to have been executed by the father of the plaintiff number 224. As such, no decree can be passed on admission. So now, what is wrong?
Wrong is that in the plane, this deed allegedly they are saying that it was manufactured or whatever it is. Came into their notice in 2020. They did not challenge it. They amended the plane, admitting that the partition is deed is there. As per that partition deed, property is to be partitioned in their plane, amended plane. So if admitted position is there, defendant is also admitting, plaintiff is also
Place
admitting.
that portion.
11A, para 11A to 11E of their amended place.
Place the exact portion.
That is page 33. It starts from page 33. Para 11A. After going through the written statement, plaintiff came to know that subsequently the land survey number such and such situated Janglighat village was regularized being access land because they have not included this land in the suit property.
No, counsel. First you place the pleading.
Yes, sir. Under Corporate Tahsil, regularized being access land in favor of defendant number 1, 2, and 3 and let Mujibur Rahman, who was also husband of plaintiff number 1 and father of plaintiff number 2 to 4. Next, para 11B. The defendant will further disclose that during the lifetime deceased, Mujibur Rahman has executed a partition deed along with defendant number 1, 2, and 3 with respect to the land bearing survey number 924, 925, 924 by 2, measuring 3,582 square feet, that is 561 square meter and 130 square meter respectively at Janglighat village under Corporate Tahsil Southern 1, which was duly registered before the sub-registrar. As per the partition deed entered between the deceased Mujibur Rahman and defendant number 1, 2, and 3, the Mujibur Rahman is entitled to that 330 square meter of land, being survey number 925 by 1. Defendant number 1 is entitled to that area 169 square meter and area 59 square meter is survey number 924 by 1 by 1. 100 square meter is survey number 924 by 2 by 1 and an area of 10 square meter is survey number 925 by 3. Defendant number 2 is entitled to that an area 26 square meter in survey number 924 by 1 by 2 and the defendant number 3 is entitled to get 167 square meter in survey number 197. As per the partition deed entered between the deceased Mujibur Rahman and defendant 1, 2, and 3, deceased Mujibur Rahman entitled to get 330 square meter in survey number 925 out of 561 at Janglighat village, Corporate Tahsil. Survey. The deceased Mujibur Rahman died leaving behind plaintiff number 2, 3, and 4 and defendant number 4. As such, the plaintiff 2, 3, and 4 and defendant number 4 are entitled to get their respective share in the land measuring 330 square meter out of total area 561 situated in Janglighat village, Corporate Tahsil, Southern Nama, being survey number 925 mentioned in the partition. Clearly, they are admitting the partition deed properties to be done partition as per these deeds. These are main paragraphs which are then amended after getting my written statement. If they are admitting it is to be done in that, I am also admitting this to be done in that. And they have not challenged the this deed, the partition deed, though they are knowledge in 2020. Now it is 2025, up till now it has not been challenged. And it cannot be challenged beyond 3 years from the date of knowledge. In the written objection, they namesake, they file this written objection saying that because if that all the things they could have challenged after getting my written statement. Finding of
If
the-
it is at all taken into consideration that it is the admission of the plaintiff.
Yes.
For the sake of argument. It is the admission of the plaintiff that 330 square meters in respect of survey number, so they are entitled.
Yes.
Is the plaintiff number one entitled?
So plaintiff number one, they themselves, prayer kindly see one of the paragraph. They have said she is not entitled. They are themselves saying
Wherein?
the para 11E.
Hmm?
11E.
That as a disease.
Died leaving behind plaintiff number 2, 3 and 4 and defendant number 4. As such, the plaintiff number 2, 3 and defendant number 4 entitled to get their respective shares. Plaintiff number 1 is, they deleted themselves, not entitled.
Yes, learned counsel.
My lord, kindly go to page number 47, my lord. Written objection on the behalf of the
Learned
plaintiff.
counsel first go through the pleadings. We are concerned with the pleadings, order 12, rule 6.
Yes, my lord.
Let us,
Order 12 rules.
let us place order 12, rule 6.
Yes, my lord. My lord, para 3. my
Order
lord.
12, rule 6, CPC. Eight মোল্লার বই আছে মোল্লা অথর হচ্ছে মোল্লা সিভিল প্রসিডিওর কোড অর্ডার 12 বলছি এটার জন্য আপাতত ওইটা আনা বুঝেছেন
Judgment on admission.
let her place yes learned counsel place order 12 rule 6
Application, my lord.
Huh?
Application.
order
Yes.
no not the application
Yes.
order
Your
12 rule 6 of the code of civil procedure 1908
The judgment on admissions, my lord, where admissions of fact have been made either in the pleading or otherwise, whether oral or in writing. The court may, at any stage of the suit, either on the application of any party or on its own motion, without waiting for determination of any other question between the parties, make such order or give such judgment as it may think fit, having regard to such admission. Second, whenever a judgment is pronounced under sub-rule 1,
the section গুলো আছে সেকশন গুলো আছে অর্ডার 12 টা আছে ভলিউম 2 তে
a decree shall be drawn upon in accordance with the
That is the-
judgment. And
that's the second part
Yes.
second part we are concerned with order 12 rule 6
clause 1.
sub rule 1
Yes, ma'am.
where admissions of fact have been made either in the pleading or otherwise
Yes, my lord.
where admission of fact have been made in the pleading
Yes, my lord.
whether orally or in writing
Yes, ma'am.
the court may at any stage of the suit either on the application of any party or of its own motion and without waiting for the determination of any other question between the parties make such order or give such judgment as it may think fit, having regard to such admissions.
Yes, my lord. But in this scenario, my lord, when the order 12 rule 6 was filed, my lord, in that at a preliminary stage, the decree cannot be drawn because the allotted share to the respondents is not at all equal, my lord. And the shares.
Learned
which have been
counsel, learned
decided-
counsel. At whatever stage it may be, can you go beyond the pleadings?
No, my lord.
So
My lord, but my question, ma'am, but it is not a proper segregation has not been made, my lord. And it is also touching the area of the defense, my lord. And it's a low-lying area where it is not even fit
learned
for.
counsel, we are not at all concerned with the area of the land. We are concerned with the
With the
legal
pleadings.
proposition. Whether having admitted a fact that the legal heirs are the plaintiffs number 2, 3, and
3
4, and the respondent and the defendant number 4. So it is admitted that the legal heirs of Mujibur Rahman are plaintiffs number 2, plaintiff number 3, plaintiff number 4, that is 3 persons, and the defendant number 4. Apart from these 4, 2, 3, 4, and 4, defendant number 4. Apart from these 4,
Yes,
there is no other legal heir who is entitled to the share in respect of the property of Mujibur Rahman.
yes, ma'am.
It is admitted. So, once being admitted in the pleadings, that is amended plaint, can you move away from that?
But my lord,
Can you,
No, my-
So,
But my lord, even if we accept, my lord, but the point where rise is the allotted share is not equally done. Even if it is, if we are accepting those proposed scenario, my lord, but it's a low lying and it's not fit for such land, my lord. It's not even development
That-
area.
that was in respect of 11E.
E.
Now, go to 11C, that as per the partition deed entered between the deceased Mujibur Rahman and the defendants number 1, 2, and 3, the Mujibur Rahman is entitled to get an area of 330 square meters in survey number 925 by 1.
Yes, ma'am.
In the plaint, learned counsel, in the schedule of the plaint, which survey number has been placed?
925.
Huh?
Same survey.
925 by 1 or 925?
925, not by one.
925. And partitions, that party deed. You don't have the deed now at this present juncture.
Please.
What is the schedule mentioned in the deed? That is not
925.
within your knowledge at this present moment.
925.
So learned counsel, tomorrow you bring the deed. Let a copy be furnished to the other side. And after furnishing that, you produce the deed.
Yes.
On affidavit. Okay. Anything further to be submitted in respect of the query made by this court can be made tomorrow. Nothing more than that. Nil. The learned counsel representing the petitioners oblique defendants. This is an application. This is an application seeking. This is an application seeking revision seeking revision
বলে আনমিউট আরেকটা কি বলে?
the order of the order passed by order dated 12/7/2024 passed by the learned Civil Judge Senior Division Port Blair in title suit number 88 of 2019. Full stop. Paragraph. The learned counsel representing the petitioners, defendants submits that in spite of admission of the fact that the plaintiffs number 2, 3, 4 and the defendant number 4 being the legal heirs of Mujibur Rahman since deceased, the impugned order dismissing the application under Order 12, Rule 6 of the Code of Civil Procedure seeking a decree, judgment and decree on admission, seeking judgment and decree, judgment oblique decree, judgment oblique decree on admission has not been passed. Full stop. The learned counsel further submits that the learned trial judge ought to have passed a decree on admission as it has been admitted by the plaintiffs that the plaintiffs number 2, 3 and 4 and the defendant number 4 are only the legal heirs through the amended plaint through paragraph 11E, through paragraph insert করুন, through paragraph 11E insert করুন, paragraph 11E of the amended plaint, through paragraph 11E of the amended plaint, and through paragraph 11C of the amended plaint filed on 18/1/2022. The plaintiffs have also admitted that as per the partition deed entered between the deceased Mujibur Rahman and the defendants number 1, 2 and 3, the said Mujibur Rahman was entitled to get an area of 330 square meters in respect of the survey number 925/1. In the plaint also, the schedule is 925/1.
One they have not made.
One
No,
has
not
not
one.
been mentioned.
So, no, survey number, survey number be not mentioned. In survey number 925/1, 330 square meters, square meter in respect of survey number 925/1 mentioned in amended plaint, while in the schedule of the, what has been mentioned in the schedule of the amended plan?
925. Bar 1 is not mentioned.
While in the schedule of the said amended plan, only survey number 925 has been mentioned. Full stop. He further submits that considering the admission made in the aforementioned two paragraphs of the amended plaint, the application under Order 12, Rule 6 of the Code of Civil Procedure ought to have been allowed. Full stop. Paragraph. The learned counsel further submits that a certified copy of the partition deed, certified copy of the partition deed being number certified copy of the partition deed being number
Book
number.
4, volume number 150.
1 minute.
Page 20.
1 minute. Page 20,
25 of
page 25.
para 6.
1 minute, page 25.
Fourth line. Very clear.
25.
Sixth one.
Gotcha. What you have written under
Council
further submits
copy of the partition deed.
certified copy of the partition deed, partition deed being registered before the,
Sub-register.
it is not mentioned here.
Yes, that is not.
Gotcha.
Number, volume number.
তাহলে আরেকবার করুন।
The learned council further submit that the certified copy of the partition deed.
That the said
The certified copy of
the
the
certified
partition
copy of the said partition deed
deed. Partition deed.
recorded in book number 1, book number 4, book number 4, book number 4, volume number 154, book number 4, volume number 154, pages number 13 to 14,
24.
sorry, 13 to 24, 13 to 24, serial number 254 by 11, dated 5/9/2011, shall be produced tomorrow. Full stop. এই যে এটা আছে পেজ 25, ঠিক আছে, দেখে নেবেন, মিলিয়ে নেবেন। পেজ 25 এর আছে, পেজ 25 এর আছে, মিলিয়ে নেবেন। আরেকবার বলে দিচ্ছি, বুক নাম্বার 4, ভলিউম নাম্বার 154, pages 13 to 24, serial number 254 by 11, dated 5/9/2011. Full stop. Can produce tomorrow. Full stop. The learned counsel representing the opposite parties submits that the amended plaint was filed on 18/1/2022. That is after about 2 years. That is after about 2 years from the date of filing of the written statement. Full stop. He further submits that paragraphs number 11C, paragraph number 11C and 11E states mentions in detail as regards to the partition deed and the entitlement of the persons in respect of the said property in issue. Full stop. Subparagraph. She further submits that in the objection filed against the application under Order 12, Rule 6 of the Code of Civil Procedure, the plaintiffs have objected as regards to objection, as regards to admission, wherein you have mentioned.
You know, my lord, at page number 47, para 6.
Page number 47.
Where it clearly
1 minute,
states
1 minute. Page number 47, paragraph 6.
paragraph 6, that we have not denied the material fact.
Wherein you have denied,
Para
wherein you
7.
have denied of, wherein you have denied as regards to execution of the partition deed in the said paragraph.
Para 7, we have clearly stated, my lord, partition deed is a manufactured document and at no point of time late Mujibur Rahman had executed any document. So document has been.
Separately, he further submit that the objection filed against the application in the order 12, Rule 6 of the Code of Civil Procedure. The plaintiffs
The plaintiffs have
have
objected
as regards to some.
as regards to the
Admission.
as regards to the execution of the deed. The execution of the partition deed. Full stop. She further submits that the partition deed, the said partition deed on which the defendants are banking upon, is a manufactured one. Full stop. As such, the impugned order has been rightly passed by the trial court. Full stop. Submission, plaintiff submission, sorry, plaintiff petitioner defendant submission শেষ হলো ওইখানে একবার চলে যান petitioner defendant submission শেষ হলো he shall raise the
Further submission for it.
he shall place the certified.
The opposite party submit that the amended plaintiff claim was filed on.
আর আগে last line to দেখলেন না the learned counsel submits that he shall furnish the certified copy of the partition deed recorded in book number 4
Learning council for the submitted certified copy of this here,
হ্যাঁ
partition deed,
ওই
partition deed reported in Vietnam.
ওইখানটা ওর আগে ওই লাইনটার আগে
হ্যাঁ।
ওই লাইনটার আগে ইনসার্ট করুন
এই প্যারাগ্রাফটা আগে না, মানে এই প্যারাগ্রাফটা শুরু হচ্ছে মানে the learning council for the submission of certified copy.
হ্যাঁ হ্যাঁ এই প্যারাগ্রাফটা আগে ইনসার্ট করতে হবে, ওখানে অ্যাস্ট্রিক দিয়ে দিন।
মানে এই প্যারাগ্রাফে থাকবে না।
না আলাদা প্যারাগ্রাফ সাব প্যারাগ্রাফ হবে, ওটা ইনসার্ট হবে, ঠিক আছে? এই প্যারাগ্রাফটা লাস্টে হবে, সেটা
ওটাই
ইনসার্ট করবেন। The learned council has further submitted that the written objection, sorry, the written statement was filed by the defendants on 28/1/2020. And till date, no case has been filed on behalf of the plaintiffs as regards to the cancellation of the partition deed, said partition deed, which the plaintiffs are alleging to be manufactured. Full stop. এবার লাস্টে চলে আসুন। Heard the submission of the learned councils. লাস্টে চলে যাবে। Heard the submission of the learned councils. হ্যাঁ heard the submission of the learned councils. Let the matter appear tomorrow only for placing the said partition deed, certified copy of the said partition deed, only for placing,
for placing the certified copy.
for producing the, only for producing the copy of the certified copy of the said partition deed.
My lord, part heard matter,
Yes, it is part heard.
part heard.
Tomorrow,
Yes,
what is the meaning of part heard? It is fixed tomorrow.
yes. ma'am.
It is heard in full, only the deed is to be gone through. And if you have any authorities in supportive of your contention, then you can file.
Clear.
And then at council, prior to submitting and prior to producing the deed through affidavit, let the copy of the same be
I already
furnished.
so I will supply it.
Next.
Lord, I am appearing with my learned junior before my lord.
Sole opposite party.
My lord. Lord, in my humble submission, perhaps this is not a maintainable petition, my lord, because why he has asked for recalling of one of the orders, which is an order where he has asked for adjournment before the trial court. That has not been annexed to the order sheet, to the petition, my lord. My lord junior will hand over.
Have you filed any exception?
My lord, no, the matter is pending before the trial court, my lord, and The orders have been passed and they have to consider our applications. And he has asked for a prayer. If your lordship comes to the prayers, my lord, page 13.
Let the learned counsel for the.
Lordship.
What is this one? What is this one? The last order in respect of this one, by the trial court. Of the trial. The last order has been passed on 8th of November 2024.
My lord, it's the 8/11,
It is not annexed, lordship, therefore I handed over the copy.
8/11/2024. Lordship will see that order, my lord.
When I applied.
Can a
the
document
paper,
be handed
the
over
was
such-
not there.
When you had filed?
Certified copy,
Hmm.
this order was not passed. I applied earlier, subsequently, but it is mentioned in my pleadings. Lordship, my case is that this is a partition suit.
This is also a partition suit.
Partition suit, I prayed for injection, temporary injection, I prayed for appointment of receiver. And because the property.
Preliminary decree has been passed.
No, Lord. What happened in 2021, I filed the suit. One lawyer appeared on behalf of the defendant.
1 minute, 1 minute. CO. CO6, huh? CO5.
2021, I filed this
1
suit.
minute. CO. 50, CO55. You have filed the suit for partition on?
2021. Date is.
Date.
Yes. Filed on 15/4/2021.
15/4/2021, yes.
And additive injection was allowed by the trial court on 22/4/2021.
Addendum temporary was allowed on
22/4/2021.
24.
22/4.
22/4/2021.
There are notice were issued to defendants.
Hmm.
Defendant appeared.
Appeared.
by Counsel,
Hmm.
take undertaking to file a wakalatnama. Several dates taken by that counsel. No wakalatnama filed, no written statement filed. Thereafter, another advocate appeared filing a wakalatnama.
Written objection,
Nothing was filed.
nothing was filed.
Then
Wakalatnama was filed.
first counsel did not file wakalatnama even. Undertaking was given. Then second counsel filed a petition, no written statement filed, no written objection filed. Time lapse, ex parte proceeding was started. Injection application
One
was
minute.
disposed of.
1 minute. Second counsel filed wakalatnama
On 22/2/23.
on 22/2/2023. 2023. Only the wakalatnama has been filed.
Wakalatnama filed, no written statement was filed. Time was given, sufficient time was
1
given.
minute, 1 minute. WS. Neither WS nor WO. Not filed.
On 6th of December 2023, matter proceeded ex parte.
On which date?
6th December 2023.
6th December 2023. Proceeded ex parte means,
Party against defendant. Because
Proceeded
they did not
proceed-
file any written statement.
proceeded ex parte means, evidence started to be taken.
But it's fixed for ex parte hearing. As per
Oh.
order dated 6/12/2023.
So as per order dated 6/12/2023, that, on future date, it will be taken up for ex parte hearing. Acha.
Then. Township, then page, order on 27/2/2024, temporary injunction application was disposed of ex parte
On
on 27/2/2024.
27/2/2024. Injunction
Disposed of ex parte.
disposed of ex parte.
Then I adduced evidence on 8/7/2024, PW one was examined.
Evidence of PW1 on
On 8/7/2024.
8/7/2024. Thereafter,
On that day, they also filed the written statement, but no petition for setting aside ex parte was filed, which was recorded in that order on 8/7. Thereafter, they appeared, the present council appeared on 26/7/2024.
file WS, but did not seek for vacating the order of ex parte.
So my evidence was recorded on that day, documents also exhibited. Then they appeared on 26/7/2024.
Next date was 26/7.
Yes,
Hmm.
then they filed reply to show cause, written statement, recalling of orders. and all this.
26/7/2024.
Yes,
Filed, what they have filed?
they filed a show cause, reply to show cause. Along with praying ex parte vacating order. Because the written statement already on record was there.
Reply to so first and a prayer for vacating the ex parte.
Ex parte.
And my lord, acceptance of the written statement.
Whole line again matter was.
One minute also. Hmm.
12/9/24, PO was not there. My witness came. Thereafter, 8/11 matter was fixed. It was adjourned on that. Main contention of the defendant in this suit, it's a partition.
1 minute, no. 8/11/2024, lauded advocates for the contesting parties are present. Today is fixed for hearing of the injunction. Injunction application.
The injunction was already disposed of.
What were you doing?
Injunction already disposed of.
At the time of passing the order, it was not dictated in open court.
Sometimes it is dictated, sometimes it is not dictated.
Other advocates for the plaintiff file a petition praying for adjournment on the ground. The advocates of the plaintiff
My
file
lord,
praying for adjournment on the ground mentioned therein. Petition shown to other side, heard, considered allowed, hence case is adjourned. 17/1/2000, 17/1 for hearing of the
my lord, all the applications, that is a mistake probably in the writing, my lord.
or hearing of the injunction application.
My lord, it will be the show cause petition, ex parte vacating petition and acceptance of written statement. Actually, that is a mistake.
Injunction has been disposed
Yes,
of.
that has been disposed of, but these are the applications pending. So how is he aggrieved, my lord?
Lord Council. Injunction, as regards to status quo. Status quo in respect of possession, nature and character of the suit property.
Lordship.
So you don't have any objection to that?
My lord, I will not say anything on that, my lord. Whether this is maintainable in this light, my lord. They take adjournment and they come before my lord.
Let them now submit.
Lordship.
Considering the entire conduct, 2021, now 2024. they have deliberately, willfully dragged the matter, engaging by defense counsel, not filing a written statement, even though now they have filed. My contention, my prayer may be seen in that application.
Learned
What I
counsel,
paid
learned
for.
counsel, first of all. Suit for,
It's a partition suit.
Partition.
It's a suit for partition.
so
My contention is they are dragging the matter, enjoying entire property, dragging the.
so what
matter.
is your prayer now?
My prayer is expedient disposal of the suit. Nothing more.
Learned counsel,
My lord, my lord, I have nothing to say. I bow down to my lord. Question is, my lord, I was unrepresented, which is why ex parte. Now, my lord, we have come back.
learned counsel, nothing more to be said.
Lordship, lordship.
I want early disposal of
Kennebec.
the suit.
Kennebec. He seeks an early disposal of the suit.
My lord, that I will also be seeking. Only thing, my lord,
Do you
my-
have,
he has prayed, my lord. Lordship will see the prayer once, my lord.
do you have any objection to his prayer?
No, I have an objection to his prayer, my lord, at page 13. Lordship will see the prayer. Lordship kindly looks at page 13, my lord.
Set aside the order number 23.
He prays for adjournment. He is asking for setting aside that order.
Nil.
So Lordship sees, what is this prayer? Is this maintainable?
Lord counsel, I am dictating the order.
Lordship, Lordship. My application should be first considered, my lord, because without my applications being considered, my lord, the suit cannot proceed. That part is there.
Before the trial court.
Yes, my lord.
This is, this being a revisional application against which the petitioner or petitioners, petitioner plaintiff and defendant respondent.
Yes, my lord. Defendant respondent.
The petitioner plaintiff has approached this honorable court. Full stop. The learned counsel representing the petitioner plaintiff submits that this is a suit for partition. Full stop. He further submits that the said suit has been filed on April 15/4/2021 and an interim temporary order of injunction was passed on 22nd of April 2021. And as per the directions, as per the provisions of law, notice was served upon the defendant, respondent defendant. He further submits that the learned counsel had represented initially. He further submits that initially a learned counsel was representing the respondent defendant, but he had not filed any wakalatnama, and thereafter another learned counsel entered appearance on behalf of the defendant, the defendant, and filed wakalatnama, but did not file any written statement or written objection against the application praying for injunction. So you are the third counsel.
My lord. I'm not, my lord, my learned juniors are there, lord, before the trial court.
It is presumed that you are the senior.
Lordship.
So he further submits that thereafter a learned counsel has been changed on behalf of the defendant. Full stop. And the present learned counsel is now representing, and the present learned counsel is now representing, and the present learned counsel who is representing the respondent, herein, is representing the defendant before the trial court. He further submits that the he further submits that on 6/12/2023, the learned trial court passed an order directing that the matter will be heard ex parte. He also submits that on 27/2/2024, ultimately the application seeking injunction was disposed of ex parte. Full stop. The learned counsel further submits that evidence of PW1 took place on 8/7/2024. He further submits that on the very date, that is on 8/7/2024, written statement was filed on behalf of the defendant, but no application was filed praying for vacating the order of ex parte or accepting the written statement. The learned counsel further submits that on 26/7/2024, on behalf of the defendant, so cause and prayer and an application praying for vacating the order of ex parte and acceptance of the written statement was filed. Full stop. Subparagraph. The learned counsel further submits that this is nothing but lingering the list and harassing the plaintiff, as such seeks for an order directing early disposal of the suit for partition. Full stop. Paragraph. The learned counsel representing the respondent, defendant, submits that the plaintiff had sought for adjournment on 8/11/2024. And written statement has been filed before the trial court. Full stop. Paragraph. Consider the submissions of the learned counsels. It is fact that the list is a suit for partition. Full stop. It is also fact that on behalf of the defendant, several learned counsels had entered appearance, and the present learned counsel representing the respondent herein, who is also representing the defendant before the trial court.
Milord, kindly don't write that, Milord, because I'll not go before the trial court. My juniors will be there. Kindly don't write that, Milord. I may not go, Milord.
Last sentence. Bolu.
It is also the fact that on behalf of the defendant, several learned counsels have entered appearance for entered appearance.
Have entered appearance and ultimately um, written statement has been filed just on 8/7/2024 and on 26/7/2024. So cause along with ex parte vacating petition and an application praying for acceptance of the written statement has been filed.
Lordship.
Full stop. Considering the aforesaid facts and circumstances, the learned trial court is requested to dispose of the partition suit at the earliest without granting any adjournment,
Milord, unnecessary, because our
flimsy or oblique unnecessary adjournments
Lordship.
sought for by any of the parties. Let the matter be disposed of at the earliest.
Lordship.
Learned counsel, time.
6 months. Worship, pleadings
I'm
of-
grateful, Milord.
Things completed.
Hmm.
Issues evidences to be lead.
Learned counsels, after the direction of the apex court, time cannot be framed.
You may try to, Your Worship, preferably not binding, preferably within 6 months as your Worship.
Learned counsel,
Would it be your Lordship's pleasure to add one line, considering the applications that are pending? Considering the applications that are pending.
that will be disposal of the list includes everything.
Lordship.
Learned counsel,
But sometimes, Milord, it happens that the trial court say that it has not been stated clearly. Therefore, Lordship knows that, no?
ultimately, we have to keep in mind that it is a.
Just adds one line, Milord, including disposal of the application, pending applications.
Learned counsel, preferably within 6 months.
Great.
Preferably within 6 months.
The
Uh,
applications, my
not-
lord.
Not applications, the list.
That is
Lordship, as your lordship says.
Last.
Considering the opposite facts and circumstances, learned trial court is requested to dispose of the partition to.
And dispose of the partition suit and including the applications pending filed on behalf of either of the parties. And if possible, requesting the trial court to dispose of the suit, preferably within 6 months.
Probably 6 months is too short a time. So many matters are there, my lord, and then civil power is not there. All those difficulties are there. Frankly speaking, I know your lordship knows it better than me.
Civil power is not there means?
Sometimes the civil power is not there and the matter cannot be taken up by the court. That has also happened, my lord.
I think herein, both civil and criminal powers are,
No, there is one order I saw there. It says that the matter is adjourned because the civil power is not there. That is also there.
before this court, this is not the problem? No.
No, no.
The revision application, the instant present revision application is disposed of.
Some dates change in other two matters.
Huh?
Dates change in other two matters. Order will be same.
Which two matters?
Number 6 and 7, Lordship.
6 and 6.
So, Lord Counsel, you are representing
Yes, yes. 6 and 7, my lord. My learned junior is there, my lord. Yes. But, my lord, I believe 6 months would be too short a time, my lord. Your lordship will kindly keep that in mind and make preferably some adjustment subject to my lord's pleasure.
just preferably.
My lord, because 6 months probably.
Lord Counsel, on behalf of the plaintiff, examination in chief has been completed. Cross-examination, and on behalf of the defendant, let us move.
My lord, instead of 6 months, if your lordship would extend it to 1 year, so that would be, my lord, safer in my humble submission, subject to my lord's pleasure. I am not saying anything, my lord. Your lordship knows the reality, my lord. That's why I'm saying, my lord, 12 months or within a year, my lord, would have been preferably safer, my lord. Otherwise,
Lord Counsel, before the annual vacation,
Yes.
before the annual vacation,
lordship,
or your 6 months, wherein it is written? Preferably before the annual vacation of 2025.
lordship,
That is sufficient time to pass
lordship,
preliminary decree.
lordship. But after preliminary decree, the other part remains, my lord.
We are not at this stage, we are not concerned with the other part.
But that is there, my lord. Your lordship knows it very well.
For passing of the preliminary decree.
Lordship, lordship. I am grateful, my lord.
For the preliminary decree, ঠিক আছে?
My lord, there was another matter similar in nature which has gone to the court number 1, my lord. The same type of order should have been passed. By mistake, I think
Also, that will have to be mentioned. That will have to be mentioned.
may I mention it before my lord so that it is taken up by your lordship? I'll mention before the other court also tomorrow morning.
Before the senior judge.
Lordship, lordship. I'll do that.
Yes. So in respect of item number 6 and in respect of item number 7, same and identical order?
Lord, it should be because we had, or in one or two matter, in one matter, my lord, the applications have been disposed of, probably. Applications have been disposed of.
Let us take up one after one.
Lordship,
6. Item number 6. 6.
Here, Your Lordship, there are
What is the difference?
sole claim.
the ex parte order is recalled, my lord. Ex parte order is recalled. My lord, page 112, my lord.
Item number 6.
It was also filed same date, identity was same date.
1 minute. Mr. Prokshi.
My lord, the order dated 16/8/2024, which is at page 112.
Learned Counsel, as regards to this one,
My lord.
the plaint has been filed on
15 April 2021.
same. complaint filed on 15 April 2021. Ad interim temporary order of injunction,
22/4/2021.
same date, 22/4/2021. Herein also the order of ex parte dated 6/12/2023.
Yes.
6/12/2023. Injunction disposed of ex parte on
In between, there was a receiver application also in this case.
receiver application. Yes. 1 minute, Learned Counsel.
Just I'm pointing out.
Is it annexed?
Their order sheet.
Annexed. From which page?
Temporary injunction was disposed on 15/3/2024.
Oh, not that, not 22nd of April 2021.
It was fixed for ex parte or fixed for ex parte. Ex parte was fixed on 11/10/2023.
Wherein you have mentioned.
Page, order sheet. On clearings also mentioned.
In the petition, it has been mentioned. Um,
Page 6, you know, paragraph 6. Ex parte hearing, I mentioned.
Title suit filed on. Paragraph 6.
Paragraph 6.
Even the matter was fixed for hearing of injunction of would not appear. When the matter was fixed for expert hearing. I don't know that on that case. Another council in the assignment perform command has appeared and filed Wakalat Mama. Okay, Mr. Okay. Can you do? Can you do? Yes. Okay. Okay. So there will be the change of dates.
Date 15/3/24, ex parte was fixed
Okay,
again
okay,
then.
okay.
The 7/6/2024 receiver was appointed. Ex parte hearing, receiver was appointed.
An application seeking appointment of receiver was preferred by the plaintiff. Petitioner plaintiff, which has been disposed of ex parte on Learned Counsel.
7/6/2024.
7/6/2024. 7/6/2024. Okay. Where in which paragraph you have mentioned?
Paragraph 7.
Paragraph
Page 6,
7.
paragraph 7.
The petitioner stated an opinion on that. If the appearance of the defendant, however, the said opinion appointed chair on 7/6/2024. Appointed as receiver. Or appointed as receiver. Any other
Yes,
new
they
fact?
appear 25/7/2024 file petition for vacating ex parte, which was vacated.
Gotcha. Ultimately, on 25/7/2024, the on behalf of the defendant, an application. So cause was filed along with application praying for vacating the ex parte order. Ex parte order means in respect of injunction, receiver, all.
My lord. Page 8, my lord. Page 8. Lordship sees page 8.
Okay.
What were the applications?
Vacating the ex parte order in respect of all injunction.
Dated only 10/7/24.
Huh?
10/7/24 order they want to vacate.
Acha. Fourth application was filed for recalling the order dated 10/7/24. 10/7/24 is which order?
By which the
You have
asset.
directed the SHO to assist the receiver.
Acha. As regards to receiver,
All of the orders were passed ex parte, my lord, which is why we have entered appearance and we have prayed for recalling.
all the orders have been passed ex parte, that is clear. But as regards to appointment of receiver, you have not filed any application.
Yes, we have filed applications. Yes, that is there also. All those applications are pending, my lord, and that is to be considered by the trial court on its own merit.
9/7/24. Okay. The learned advocate was appointed. No, I think it was 7/6/24. The application of which was issued to the receiver. Okay. Okay. Ultimately, you appeared on
My lord, on 25/7/2024.
ultimately the herein also the third learned council.
Yes, my lord. Third. I think so. Subject to what my learned friend will say, my lord.
Third. Ultimately the defendant, respondent defendant through his learned counsel filed show cause and several applications praying for vacating the ex parte order
Lordship.
on date 25/7/2024. Anything more to be, the evidence has started?
No, in this case, no.
No.
The
All
learned,
the applications are fixed, my lord, on 17/1.
the learned, both the learned councils further submit that on 17/1/2025, it is fixed for hearing of all the applications. First up. The learned council representing the. What's the chapter there? Same. Yes. Same as the earlier one. Yes.
Lordship.
Same as the earlier one.
Lordship. I am grateful, my lord.
There two plaintiffs, two defendants.
Gotcha. Item number 7.
7. Filed on date same.
What is the difference here?
Here the injunction was refused in this case initially.
Partition suit.
Partition suit injunction was refused on 22.
Injunction refused.
On 22/4/21. was refused.
No. Correct. The learned counsel representing the petitioners.
No, petitioner is one, my lord. Defendants are two.
No.
Plaintiffs.
Oh, sorry. I'm sorry.
Mahesh,
I stand corrected.
one and another.
Yes, my lord. I'm sorry, my lord. I tender my apologies, my lord.
The learned counsel representing the petitioners submits that the plaint seeking partition has been filed on 15/4/2021. 15/4/21. Yes, explained. And he further submits that the learned trial judge refused to pass an order of ad interim temporary injunction against which you preferred miscellaneous appeal. Gotcha. Against which no miscellaneous appeal has been preferred. Yes,
On
next
24/11/23, injection application ex parte was
on, he further submits that on 24/3, 24/11/23, 23, ex parte order of injunction has been passed. Next.
the receiver in this case was also appointed.
He further, and a learned advocate has been appointed as a receiver
On 15/7/24.
on 15/7/2024.
Then 26 July 2024, they appeared by filing different applications.
Acha. If ultimately on 26/7/2024, the defendants, the defendants filed. What they have filed?
Written statement,
They have filed the written statement
try to show cause,
along with show cause,
praying for vacating ex parte order.
And application praying for vacation, for vacating the order of ex parte and application praying for acceptance of the written statement.
Lordship, Lordship.
Any other application, Learned Counsel?
My lord,
Against receiver or anything? Any other application?
there is another application for withdrawal of the receiver. For that order also probably, my lord, it's there, but it's not there in the records, I believe. Should have been.
When it has been filed, the application.
My lord, your lordship will say, and all other pending applications will be considered. That your lordship has passed the same order, your lordship can pass.
The learned counsel representing the respondents, defendants further submits that on behalf of the defendants, another application has also been filed seeking recalling of the appointment of the receiver. He further submits that all these applications are pending.
Lordship,
And the next date is fixed on
17-1.
17/1/2024 for ex parte hearing.
No, for hearing of these applications, my lord, expertise.
All applications, sorry. Next date is fixed on 17/1/2024 for hearing of
25, my lord,
filed on behalf of the defendants.
defendants.
In the earlier matter also same. Yes. Consider paragraph. Consider the submissions of the learned counsels and considering the facts and circumstances and specifically considering the is a partition suit. Eva?
Rest your lordship will pass the same order, the same. Lordship, I'm grateful, my lord, I'm grateful.
As regards to the other one, be kind enough to mention before the learned.
Lordship, I'll do that. I'll ask my learned junior to mention it tomorrow, my lord.
So these three items are disposed of. 4, 5 and 6.
4, 5 and 5, 6 and 7, my lord.
5, 6 and 7.
Yes, all three disposed of. my lord.
Yes.
I am grateful to your lordship.
Yeah,
Least after 2 weeks.
Time for the respondent number 2 states.
Respondent,
2.
respondent hearing.
Mr. Vishal Kumar Vishwas is appearing for the complainant here, Your Lordship. Rightly is unless let the matter may be fixed on any other date, Your Lordship.
Which
Next
date?
week.
Which date?
Next week.
Which date?
Wednesday, Your Lordship.
Hmm?
Wednesday.
Learned counsel. Had to submitting, you
Yes,
should
yes.
have the full
I will take
information,
instruction.
instruction. On,
I will take instruction.
when will you take instruction? After completion of
Now only.
hearing?
Now.
You take instruction and submit before the court.
Next week, Tuesday, Your Lordship.
Monday,
Your Lordship.
Monday, that is
13.
13th of January.
13.
No.
It's a complaint case, lordship. Enter proceeding have been challenged by the petitioner hearing.
So, enable. The petitioner is being represented by owner now, while the respondent number private. You are the complainant. The complainant being the respondent number 1, while the complainant being the respondent number 1 herein is being represented, and the learned PP or the prosecutor is representing the state. Full stop. Any other respondent?
No, two respondents, one and
respondents, 1 and 2. The learned counsel, learned advocate, representing the petitioner, seeks an accommodation on the ground of a senior. Let the matter appear. 6 weeks time on the ground of a senior. Let the matter appear on 13th of January.
Okay.
Learned counsel, come prepared. On that
Yes.
matter, it will be taken up.
Item 9, there are 22 or 24. This is appearing for the petition from item number 9 to 16.
My lord, my senior Mr. Rakesh Pal Govind is appearing for the respondent.
Hmm.
Your Honor, let the matter will be fixed next week, Your Honor, as my senior is out of station, Your Honor, for his medical checkup, Your Honor.
When will it be available?
After 13th, Your Honor.
What is your submission?
My lord,
What is your submission?
my lord, there is an application for causing affair, my lord.
You are ready with the hearing?
My lord, on the next day.
Today you are ready with the hearing?
No,
Why not?
my senior is not there.
Hmm?
I am the junior, my lord, junior counsel. RE counsel is not there.
You submit.
My lord, I'm paying for time.
That you say. Why didn't you mention it earlier? Why didn't you mention it earlier?
My lord,
You are the,
I am for the petition, my lord. Senior is
yes,
appearing for the
you are the
petition.
petitioner.
My lord.
It is to be submitted by you first,
My lord, we are ready, my lord.
then submit.
As my senior is not there as the
Learned counsel. On the one hand, you are saying that I am ready. On the other hand, you are saying that my senior will submit.
But my senior was there to argue matter, but as the other side is not there for the reason, my senior is left with the for that reason.
Learned counsel, this is not at all appreciated by the court.
I know.
This submission which you have submitted today, just now, is not at all appreciated by the court. You will have to submit fairly.
Right.
The learned, or the non-terminable, learned advocate seeks an adjournment on the ground of his senior, full stop. The learned advocate representing, give your names. The learned advocate representing the Central Bureau of Investigation submits that learned name,
Rakesh Pal Govind.
Mr. Rakesh Pal Govind.
Yes, Your Honor.
Mr. Rakesh Pal Govind, learned advocate representing the Central Bureau of Investigation. Is ill. As such, he seeks an accommodation for this week. Full stop. Consider the submission of the council. Let the matter appear on,
14th, Your Honor.
let the matter appear on 14th of January.
Obliged, Your Honor.
In respect of item number
9 to 6.
9 to 16.
9, 10. Take it in.
Item 10, CRI 23 of 2024. And project.
Same.
Same.
Yes, sir.
Item 11, CRI 24 of 2024.
Same, Your
Same.
Honor.
Item 12, CRI 25 of 2024.
Same, my lord.
Item 13, CRI 26 of 2024.
Same.
Item 16. Item 14, CRI 27.
Same, my lord.
Item 15, CRI 28.
Same, my lord.
Item 16, CRI 20. Same.
Same, my lord.
Item 17, CRI 54 of 2024. CRI 54 of 2024.
Filed everything servicing matter.
And the respondent state lordship in item number 17.
Other respondents,
Others,
I appear for one of the respondents.
learned counsel, be on this side.
respondent.
Otherwise, court cannot recognize.
My lord. But I appear for one of the respondent in CRR 54 of 24. That is item number 16 and 17 are interconnected.
17 and 18.
No, 16 and 17.
Okay.
17 and 18, my lord. 17 and 18 are interconnected. So far as 17 is concerned, I appear for one of the respondent, namely,
How many respondents are there?
Lord, there are
Six. Six. State is the respondent number 1.
yes, state is the respondent number 1. There
Respondent
are other
number-
5 private respondents.
You in CRR 54 of 24,
Yes,
that is item number 17.
yes, madam.
You are representing respondent number 2,
Neeraj Kumar.
Neeraj Sharma.
Yes, my lord.
Learned counsel, in respect of the respondents number 3, 4, 5, and 6, Vinay Kumar, Aman Sharma, Praveen Kumari, and Shashikala.
Lord, Mr. Kabir shall be appearing in for all the remaining respondents, private respondents. So my only humble submission is that let them give me a copy. They are telling that they have already served it.
Yes,
I just want a copy of
We
that
will give
so
it.
that we can get a
We have
printout
started.
of it and we can
There is a
share
subject
it.
report, we have filed it. Everybody
Yes.
is.
Kindly see where the respondents are residing.
Learned-
They are residing, what is
Learned
the harm in
counsel-
them
learned
giving me a
counsel.
copy, my lord?
Learned counsels, we are here to hear out the matter,
I'm grateful.
not to go into the integrities
Yes.
or
This is first time he has demanded, I will give him.
Copy.
Give it to me.
The first time you are appearing?
Yes, for the first time I'm appearing, my lord, and I undertake to file
In respect of
only for one particular respondent, my lord. Respondent number 2.
respondent number, PP, you have got it?
Lordship,
Yeah, you already got. As regards to 3, 4, 5 and 6,
Lord, I was told by Mr. Kabir that even he has not received any of such copies.
So I have
Has-
served the copies to them in the Pathan.
has,
Only one copy can be provided for Mr.
I
Kabir also. He will share for all of them.
is he representing?
Yes,
Has
sir.
Wakalatnama been filed on behalf of 3,
I
4,
have
5
been
and
told in
6?
the morning that he shall be filing his wakalatnama.
Nobody is here to represent 3, 4, 5 and 6.
Lord, I think he's on his legs in the
There is
parallel
another-
court, Lord. Let me check out.
At least somebody should be there, learned advocate. Some learned advocate should be representing him.
Lord, let me check out, my lord. Just there we.
So if any copy has not been served upon the
Copies
respondent,
have been served on the party personally.
You have said- you have
On
said-
demand, I
Not
am telling
personally,
you.
Lord, they are residing
Will give
in,
them.
how can it be
I'm
served
on-
personally?
I am
They are
unable to,
giving, they are asking for the first time. I am assuring that I will be giving them.
That's it.
I am able to understand.
Mathematics here.
Let a copy,
Or
Great.
I will give
the
them
application
ready.
be served
in the course of.
during the course of this day.
And the course of the circuit.
No.
Course of the day,
Learned council. We shall have to be serious about the
Yes,
matters.
yes,
We will
yes.
serve.
It is not, it is
Lord,
not.
I was told that in the course of the circuit they will serve. So I
The
said,
course of the day.
hey, then it's okay, Lord. If I get it in the course of the day, then it's okay.
I will send it to your chamber.
Yes,
Yes,
I'm grateful.
They, what to be noted about respondent number
I'll
3,
just
4, 5 and 6?
Come back, Lord.
Yes. At least there should be someone
Okay, so
We will supply the
representing.
copy. We will supply the copy. Without-
The
I assure them.
petitioner, the petitioner is being represented. While the public prosecutor is representing the state. And learned advocate. Learned counsel is representing the respondent number, opposite party number 2.
Three, 4, 5 and 6. The difficulty is I have received one of the applications. The state has filed one that I have received the copy, but so far as the one filed by
State has filed item number
18,
18,
80.
CRR 52, Lordship.
52 of 2024. You have
Connected.
received that,
I have received the one filed by the state.
Mr. Kabir,
Respondent.
respondent, my opposite
Oh,
party.
sorry. I'm sorry. Hey, Shumit. Shumit, the petitioner. He is also respondent. In
Oh,
animals,
no, no,
actually,
no,
we
no,
stand
no.
on the opposite side.
Whichever side you prefer, you can stand. But respondents, opposite party should be on the one side, and the petitioners should be on the other side.
Then in one case,
No, no, okay. In this case, it is adjustable.
Anyway, so far as initial,
So-
the revision revision petition is
So
concerned, that
the-
was 500 Tulsi.
Huh.
That one we have not got the copy.
Mhm. So in respect of CRR 54 of 2024,
Yes.
CRR 54 of 2024, the learned councils representing the respondents number 2.
2 to 6.
CRR.
That's recently being included on the public prosecutor in including the state. And
Two separate orders in the items? Two
Since they
separate
are
orders?
tied together, it can potentially.
One. अच्छा, তাহলে, কি লিখেছেন বলুন তো? The petitioner Jagjit Kumar. In the item number 18, the opposite party is not the same. Jagjit Kumar is not the opposite party.
There are Jagjit Kumar is the complainant.
Achha.
So
De facto
discharge has
complainant.
happened in respect of my clients.
Hmm.
And we are all the family members of the husband. And the husband
The
was
suit
not.
involves, the suit involves,
This is a matter where there was a naval officer posted over here. He had his wife and child. Now, this particular officer was having some sort of difficulties. On that given day, the wife and child were found dead in his residence. So initially there was a huge hue and cry. That's a case of murder, this, that, all that happened.
in the said residence, only the naval officer and his wife
And
and
his child were there.
child were
My
there.
clients have never even come to Port Blair. We are all the family members. We stay in Rajasthan and other parts of India. Now what happens is the investigation proceeds on the assumption.
who is the naval officer?
The naval
I
officer is
am
Neeraj.
representing the naval officer.
Neeraj Chopra.
Neeraj Sharma.
Uh,
Neeraj
sorry,
Sharma.
Neeraj
Neeraj
Sharma.
Sharma.
Neeraj
Acha.
Kumar Sharma.
So Mr. Elango is for him. Now what happens is the initial case proceeds on the assumption
You are representing
all the family members.
Father, the
on
mother.
on the date of occurrence, you were residing.
At Pathankot,
We were in the mainland India.
Pathankot.
Acha. And you?
I am the complainant.
The father of the
I am the
girl.
complainant.
Father of the deceased.
wife.
Father of the deceased.
I am the
wife.
Now, when we say deceased, this is what I wanted to impress on the court. Initially, the case proceeds on the assumption that both mother and daughter were killed. When the investigation actually happens, it is found that the mother strangles the child. The
This is
daughter.
what, this is all.
Let me make my submission, then my
This is
learned
all
friend
off the
will
record.
counter it.
These are all
No,
off the record.
it is not off the record, it is
These
part
are
of the
off
record.
the record.
Let me make my submissions
Come on,
uninterrupted,
come
then
on,
the council will counter
Sorry,
it.
off the record.
Learned councils. Learned
Is
councils.
he-
Learned
Now,
councils, let me be clear. If each and every
Question is the supplying of
Learned
copy,
counsel.
we will supply the copy, what submissions are being made, these are off the records.
No, nothing.
my
off the record.
submissions, I will make my way.
let me be clear.
This is not the way.
Each and every learned council will get ample opportunity to submit.
This is my petition.
Yes.
Their content
Let
is.
them get the copy.
They have not received the copy. I assured them that I will be giving them the copy. That's not.
So when can we take up the matter?
My lord, the other difficulty I find in the list, there are 4 crans. We don't have
Yes.
copies of anything.
Cran 1 of 24.
Probably
Can
1 and
two-
2 are connected to the first CR. Then the next 1 and 2 are connected to 52. We are not sure what is the situation.
No,
Acha, that is a
It's our
problem of
problem.
the server.
Okay, so then, my
No
lord,
crans
then
so far.
in any event, we are not unaware of those.
Though, see, cran 1 and cran 2 of 24,
So 1
which has been
and
filed by
2
the state.
by the state, probably section 5 korocho, na?
Section 5.
So section 5 application act, or not? So whichever it is, these 2 crans, we don't have copies. So we are not clear what it is. One must be a section 5 because as I understand, initially CRR 54 was filed.
Cran 1 of 2024.
My lord, but that is probably in connection with
Section 5.
50.
One is
Section
for,
5.
one is for, that is CRF 54 for staying the operation of the learned tribal, right?
1 minute.
It's not my crime. I have not made
One
mistake.
Acha. Then my cran,
Yes, your
my cran.
From what I
Yes.
understand, initially
by-
one
Let me be
section was
clear.
filed.
Let me be clear. CRAN Cran 1 of 2024
Section 5.
has been filed in respect of CRR 52 of 2024.
That is the state.
That is
state,
filed by the state,
State.
praying for condonation of delay
My lord,
under Section 5 of the Limitation Act.
my lord. So first of all, let that be served upon us.
1 minute. And the other two, where is the, oh, Cran 2, yes. CRAN 2, that is also filed in CRR 52 of 2024. That is by the state.
Lordship.
Let's shoot in the matter of.
Stay of operation of the impugned order.
Yes, that is for a stay of the operation. That's.
What is the prayer, Learned Council? Yes, application for stay of the order number 22,
Lordship.
dated 29/7/2024. Whereby the learned sessions judge discharged the respondents 1 to 4 from the aforesaid session space.
Matter was fixed for charge, Lordship. 1 accused have been laid, 4 have been discharged. If not state, that is difficult.
No, that cannot be because an order has been passed. We are no longer part of the proceeding. Now, even if my learned friend wants to continue with the trial there, till the order of discharge is set aside, we are not part of that proceeding.
Let the Cran 1 be
That's
first
what I'm saying.
disposed of.
And I was just giving your lordship a bit of the background of the.
Yes, yes, yes.
So both the application copy today, within 5 minutes, I will serve it in that.
Let
second.
the matter come on Monday.
why not earlier?
And to be very honest, these matters, I have to get my instructions from Calcutta.
Lordship, I have also some personal difficulty. One surgery was conducted on my knee just 7 days back, Lordship. I cannot stand long. So I am also praying on the next week,
In-
Lordship.
In that circumstance, you will be given the advantage of
Lordship, next week can
submitting
be
being
fixed.
seated.
Lordship.
There is no hindrance to that
Lordship,
effect.
I will be available. I will be
Only hearing is to be done.
available. Lordship.
So Nim.
LCR is to be called for.
Let us take the CRAN 1 of 24.
My lord,
If it is allowed, then
well, we'll think further.
next step.
My lord.
Only 17 and 18. One order will be passed. ठीक है तो? CRR 54 of 24 and CRR 52 of 24 are in respect of one single incident. Single incident. Full stop. CRR 52 of 24 has been filed on behalf of the state, and in the said criminal revision, 2 applications have been filed. One being CRAN 1 of 2024, seeking condonation of delay in preferring the revision, while the other application being CRAN 2 of 2024 has been filed seeking stay of the
Order of discharge dated
seeking stay of
29th
the
July.
order of discharge. Order of discharge dated
29 July.
29 July 2020.
29 July 2024. Full stop. Paragraph. Mr. Kabir, Mr. Kabir, learned senior counsel and learned counsel, Mr.
Ilango, D Ilango.
Mr. D. Ilango. Mr. Kabir, learned senior counsel representing,
My lord, I am
representing the,
appearing for 1, 2, 3, 4 in the state's matter. There, Neeraj is not a party, as I see the copy.
Because I have not been discharged, my lord. So that's why I am not the party to that proceedings.
yeah, in respect of 2 matters, 2 different orders should have
The
been
thing is that, see, my lord, if it's arising out of a common order.
common order.
Now, in one CRR, if you set it aside,
Hmm.
if they are not tagged and a
Hmm.
common order is not passed, in the event that they split up,
Hmm.
kindly envisage if that court hears one, this court hears one, that would be a problem. My lord, may put it like this.
By name.
Exactly. So I am appearing for
Mr. Kabir, learned senior counsel representing
Vinay Kumar,
Vinay Kumar,
alias Vinay Sharma,
no. Vinay Kumar,
alias Vinay Sharma,
alias need not be mentioned. Vinay
Aman
Kumar,
Kumar,
Aman Kumar,
Sharma, Acha, Aman Sharma,
Aman Sharma, Vinay Kumar,
Srimati
Aman Sharma,
Praveen Kumari,
Praveen Kumari,
and Shashi Kala.
and Shashikala. And Mr.
My lord, I am not appearing in that matter because I have not been made as a party.
and Mr. Kiran, representing Mr.
Neeraj Kumar
Learned
Sharma.
counsel representing Mr. Representing Neeraj Kumar Sharma, representing Mr. Neeraj Kumar Sharma submits that they have not received the revision application copy of the revision application in respect of CRR 54 of 2024
Yes.
and the copy of the
Grand.
CRAN 1/2024 and CRAN 2 of 2024 in respect of CRR 52 of 2024.
Right.
Full stop. Paragraph. The learned public prosecutor representing the state and the learned counsel representing Jagjit Kumar submits that during the course of this day, copy of the revision application and the copy of the applications being CRAN 1 and CRAN 2 of 2024 will be 1 of 2024 and CRAN 2 of 2024 shall be furnished to the learned councils. Full stop. To the learned council. Furnish the provided to the learned council. To the learned council. Paragraph. On consent of the learned councils, the matter being fixed on 13th.
Month.
13th of January.
Great.
For hearing of the application being CRAN 1 of 2024.
It's a plan.
Abhay,
Item 19, CRR 58 of 2024. My lord, in this case, Mr. Siddharth is appearing for the petition. He is on leg before the court. Take the short password.
for the respondent state lordship, but is it connected with the maintenance matter 125 CR?
That's it. You start.
But I'm not the arguing person, but he is the asked to take password, my lord. He is on leg before the court.
Let the matter appear tomorrow. It will have tomorrow, learned council.
I'm for the state lordship.
Yes, tell him. Now, whatever. The learned public prosecutor is present, representing the state. And another means
Between
the
two private
husband,
parties.
husband has been served.
I'm not aware.
Learned council only seeking adjournment is not the function.
My lord, he just ask me to
Please.
take short password, my lord. I'm not the only.
ওনার নামটা নিয়ে নেবেন ওনার নামটা নিয়ে নেবেন list. Learned advocate representing the revisionist petitioner seeks an accommodation. Full stop. Let the matter appear tomorrow. That is tomorrow হচ্ছে 8
Abhay,
Your Lordship, in this matter, Senior Counsel Mrs. Nag is appearing for the petitioner, Your Lordship. Other side filed AO, Your Lordship. We required some time for filing reply, Your Lordship.
What you are paying for the respondent, board by municipal council along with senior council Satadru. We have filed our reply in terms of the direction passed by this honorable. They have sought time to file reply to the affidavit.
Reply to what?
To the affidavit opposition only. Petitioner has prayed for.
Affidavit in opposition filed on
Long back it is. Third September 2024.
3rd September 2024.
Yes.
Today is
7 January, Your Lordship.
so
Let the matter be fixed on 15th, Your Lordship. We'll be filing our reply, Your Lordship.
Thursday,
Your Lordship.
this Thursday.
Your Lordship.
Let the matter appear. नाम तो नहीं लेना. Representing the writ petitioners seeks an accommodation to file an affidavit in reply. Let the matter appear on Thursday, that is 9th of, day after tomorrow, 9th of January.
Your Lordship, deeply obliged.
No further adjournment granted, learned counsel. No further adjournment will be granted.
Your Lordship.
Item number 21 and 22, Mr. Jaipal is preparing for the writ petitioner. As per the instruction of Jaipal, he needs time to file affidavit in reply. They are filing affidavit in full.
My senior is appearing for
A
the
1 week
respondent.
time may be granted so that we
Mhm.
will file for a week days. So here, as per the instruction of Jaipal,
When the written opposition, affidavit in opposition has been filed, affidavit in opposition filed on behalf of the respondent number 1, 2, 3, and 4. On which date, learned counsel?
the month of December, my lord, it's
Month of
December.
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 Last circuit. In the month of November, my lord, backward. But the copy was given thereafter. They had filed and they had given saw the copy.
No, that
later.
was for the respondent, but for the record, it was three working days. Then the price is available. It was directed to be filed within 2 weeks
Yeah. The copy
from
was-
today, that is,
the copy was filed and the copy was not given to the council for.
when have you handed over the copy?
And or after the circuit. So.
When it was handed over,
In
learned
the
counsel?
month of December, first week of December, they had.
First, 1 month has passed by.
Actually,
1 month has passed by, learned counsel. Day after tomorrow.
a week, yes, no, because they are from different. They're staying, the activities are staying from other area. There is a dip.
Monday.
It's not possible then. That's what I'm saying.
Let the matter appear on Monday.
Well, 21 and 22.
21 and 22. The learned. The learned advocate representing the. You are representing all.
KMBJ.
You are.
I'm the
repre-
repetition.
Oh, you're the
My
repetition.
senior is appearing for respondent.
Respondent, all
All
respondents. The learned counsel representing the which petitioner. Are you the advocate on record?
Mr. Jaipal, I'm presenting on behalf
So,
of.
नाम तो दिए गए नाम था learned advocate representing the writ petitioner seeks an accommodation for this week to file affidavit in reply. It's not heard considered. The prayer seeking extension of time to file affidavit in reply is allowed. Let the matter appear on Monday, that is 13th of January.
My opinion may be recorded. I'm appealing for the respondent.
Then Jan Monday. Learned Council, Monday to be taken up. No further adjournment. Whatever may be.
We'll try. I'll inform them.
Have you furnished any new document or anything?
No, madam, we have already filed our opposition.
Affidavit in opposition
Yes,
has
they-
been filed.
No need.
What is generally filed?
Yes,
No
No new
new documents or new facts.
yes.
Learned Council on Monday.
The petitioner is from your Netherlands. That's the reason.
Yes, that's why
21st ship schedule and all is there.
It will be- it will-
We will try all the.
I can try.
Item 23.
I'm for the respondents, my lord.
I am PWD.
Praying for release
My
of
lord,
this matter, my lord, connected matter is 16, port number 1. Was taken up today.
Is it so?
Yes, my lord. My lord, in this matter, I have already filed my opposition, my lord, before the registry. Whether it has come? नहीं पहले ही.
Learned Council. To this effect, I'm stating that not today. Tomorrow you mention it before the Honorable Senior Judge. Not today. No order is being passed. Not today.
Then kindly do not list the matter tomorrow morning. I'll mention it.
You mention it, it will be listed. But you mention it before the Senior Judge
Right.
thereafter. But no order is being passed today. It will appear tomorrow also, but you mention it.
My lord, item 24, I beg to appear for the petitioner through online mode.
My lord, I am for respondent number 1 to 5, 11 and 12. I have filed my report, my lord. There was a direction to file a report. So I have filed my report on.
My lord, I have received all the reports and the matter can be proceeded without my filing the exception on the basis of their admission on record. My lord would kindly first, my lord, may I give the overview of the case, my lord?
1 minute. You are representing the petitioner. You are representing
Respondent number 1 to 5, 11 and 12. These are revenue.
1 to
revenue
5,
authorities. 11 and 12.
I'm representing along with senior counsel 6, 7, 8, 9 and 10.
6, 7, 8, 9 and 10.
They have already filed
We
the
have already
report.
filed our
1 minute. 6, 7, 8, 9 and 10 have filed the report. Which one is this one?
I have filed report on 19 December 24, my lord. Before the registry.
What is this one? Office of the Executive Engineer, Construction Division, that is
That is for
PWD.
PWD.
Yes.
6, 7, 8, 9 and 10.
Yes.
Who is representing the Lieutenant Governor?
I am representing them.
1
to 5, 11 and
1,
12.
the Chief Secretary, Principal Secretary, Deputy Commissioner, Subdivisional Magistrate.
My
You are
lord.
representing 1 to 5.
11 and 12.
Now, you are representing 6, 7, 8, 9 and 10. 6, 7, 8, 9 and 10. And you are representing 11 and 12.
My lord. 1
So all are,
1 to 5, 11 and 12. All are represented.
all are being represented.
Right.
Yes. No, where is the, you have said that you have filed the report. This one is the report. Dated.
In the form of affidavit, my lord, dated,
No.
I think,
That one. You have
19,
filed,
12.
the report in the form of an affidavit,
My lord.
but
Dated 19/12/2024, Miller.
And the report filed on behalf of 6, 7, 8, 9, and 10 is not in the form of affidavit.
Because we have been submitted to file a report indicating the conception of the bond, how we have been done.
Actually, 1 minute. It is, report is dated from which page? We will get. Then council,
Yes, yes.
you have filed one copy, and that too, go through page number 6. Right-hand corner, top right-hand corner.
Page number 6.
Is it legible? First line, second line, third line, fourth line. Is this expected? Certified that the work has been physically completed on 25/5/23, and that no.
Right side, it has been,
So who is to provide?
I will provide.
Learned Council, this casual approach is
No,
not
I'm
at all
sorry.
appreciated.
Sorry.
When you can provide?
Tomorrow, Lord, I will provide.
Tomorrow positively.
Yes,
And go through the entire report.
yes, yes.
If
anything is.
anything which is illegible,
I will
a
provide that
legible
also.
copy is to be provided.
Yes.
Learned Council, as regards to your report, everything is legible?
Yes, Miller.
Have you gone through?
Yes, my lord. Everything is legible, Miller.
The petitioner.
Legible तो बोलेंगे ना. Just take.
अच्छा, अपना नाम तो नहीं लेगा.
My lord, all the appearances has been given in the chat box. May that kindly be noted, my lord.
Virtual mode, through virtual mode, mention করে দেবেন. You are only representing.
Yes, my lord, I'm being led by Mr. Bhaskar Prasad Banerjee and assisted by Ms. Shalini Ghosh. My lord, due to online mode, all are not visible.
Are they present in the court?
Yes, my lord, they are present in there. They're present at Calcutta. We are appearing from principal bench.
That is the question I'm asking.
They all are present in the court, my lord.
তিনজনের নাম দিয়ে দেবেন যেমন আছে through virtual mode. এই যে earlier order এ. Earlier order যা আছে ঠিক আছে এগুলো are being represented. এবার dictation. On perusal of the report filed on behalf of the respondents number 6, 7, 8, 9, and 10, it transpires that some pages are not legible. Full stop. Next line. The Learned Council, representing the respondents number 6 to 10, submits that he shall provide the legible copy tomorrow, that is 8/1. Let the matter appear tomorrow. Learned Council,
My lord, at the top.
hearing tomorrow.
Grateful, my lord.
Achha, the affidavit. Achha, the report, a report on behalf of the respondents number, a report. এটা বুঝতে পারবেন না আমাদের এক্ষুনি জিজ্ঞেস করবেন ঠিক আছে পরে জিজ্ঞেস করবেন না a report filed on behalf of the respondents number 1 to 5, 11 and 12 has been filed in the form of affidavit has been filed, which be kept with the record. Copy has been served upon the petitioner and the respondents. Kept to the record. Let the matter appear tomorrow. এটা
Grateful, my lord.
এটা হাতে চলে যাবে এই লাইনটা লাস্ট লাইনটা লাস্ট
My lord, may I have your lordship's leave?
yes
Grateful, grateful.
Item 25, WPA 537 of 2024.
My lord, I am for the petition.
I am appearing on behalf of the respondent. If I have filed my opposition.
My lord, I'll not be filing any reply to that opposition, my lord. It's a very small matter.
সেটা আপনারা কথা বলেন yes
Yeah. I'm for the petitioner, my lord. It is a very small matter regarding an electricity connection, for obtaining electricity connection. My lord, here the petitioner, she has encroached our government revenue land wherein she has constructed a building and she has been deprived of electricity connection. This was the
so you are
application.
representing all the respondents.
My lord, I made a representation.
The same premises on electric connection is there. That I have enclosed in my affidavit, the field report of this start. In my affidavit in opposition.
Affidavit in opposition, 1 minute. Affidavit in opposition on behalf of the respondent number 1 and 2.
That's it.
1 minute.
Page number 6.
Respondent number 1 is the superintending engineer. Respondent number 2 is the executive engineer.
That's it.
Why are you not representing the respondent number 3?
I am-
Assistant,
I am appearing on behalf of all.
all.
It is typographical error. All the response.
Gotcha. For the respondents, okay. In which paragraph, learned counsel? You have stated
Paragraph 3,
that before traversing each and every
A.
allegation,
that is
Content.
A, in A.
Huh?
I have written A, Lord. Subpara A. That after
Acha.
receipt of the application.
that after receipt of the application for the grant, place it.
That after receipt of the application for grant of the electric connection upon the house of the writ petitioner, the official staff of the concerned area had inspected the house and it was found that already there is an electric meter installed in the RCC building bearing the consumer number such and such in the name of Jay Prakash in the same premises which was encroached upon government revenue land by the writ petitioner.
So now what is your prayer?
My
now?
lord, the petitioner herein is an Aarti Majumdar. My lord, the act doesn't restrict numbers of
So
connections, my
you
lord.
are occupying.
The encroacher,
My
not the.
No, counsel.
Sorry.
Let him submit, let her submit. So you are occupying the government revenue land.
My lord,
Yes.
my lord. There is a settled principle, my lord. There is a case laws wherein it is been clearly stated that if an occupier is in settled position, he has to be given an electricity connection upon a consideration.
Passed by honorable court, 3
Honorable.
judges bench.
It's a larger bench. Judgment is there, my lord. Abhimanyu Majumdar was a state superintendent engineer and another. You are, my lord.
CJI and Honorable Justice Bhaskar Bhattacharjee and Honorable Justice Pinaki Chandra Ghosh.
My lord, on that particular note, my lord, I am just seeking a relief from this honorable court. Let a connection may be given to this petitioner, my lord. She is a lady. She is unmarried. She is in a position of a bird because they need to ascertain the party is in settled position or not because they only claim.
They will come to know that whether.
My lord,
Anything-
it's an inspection.
Anything further to be submitted?
No, my lord. No, my lord.
Lordship, as per the report, in the same premises.
Is there any
same
hindrance?
Lordship,
Is there any hindrance in providing?
yes, Lordship, because already it is for livelihood. One connection is there. They are the encroacher. They are not the legal occupier. They are the encroachers, Lordship. One connection is there. They can use it
My lord,
because we are dark of electricity in Andaman Nicobar Island, Lordship. We are generating from the diesel.
I
From
cannot.
the gen set, we are providing. And the general people are suffering, Lordship, because due to this providing the electricity to the encroacher. Already in her house, one connection is there. What more she requires?
My lord,
It is for livelihood. We have already provided for livelihood. So this is my submission, Lord.
My
Lord
lord,
Counsel.
I may be allowed. My lord, I cannot take an electricity of others. My lord, it is very clear theft of electricity. If I'll take a line from them, they'll surely file a case against me. My lord, it is not possible for
Learned Counsel,
now.
be kind enough to hear the other side. You will also get the opportunity.
My lord, it is very clear in their in the Joint Electricity Regulatory Commission. It's been given in a definition part, theft of electricity. I'll be book on theft of electricity if I'll do the same. And bar is not there, my lord.
Learned Counsel, who is Jaya Prakash?
I don't know who is Jaya Prakash. And there are number of judgments, my lord. Electricity in an encroachment area.
It is a RCC building, Lordship. 2 floors RCC building.
My lord, it is not
It
the picture
must
is
go-
there, my lord.
Show,
Picture is there.
show that a separate connection is required. Show.
That is not needed, Lordship.
My lord,
It is not needed in the expedition.
Let her submit. You will
my
have
lord,
opportunity.
Jay Prakash, I'm not aware of Jay Prakash. I don't know who is Jay Prakash, my lord. I'm seeking a connection in my name, my lord.
So you file an affidavit in reply.
My lord,
Within
my lord, 2 weeks,
2 weeks,
my lord, because
I thought 2 days.
actually
on
presently
Monday.
she is out of station. This petitioner, she is out of station. That's the reason I've chosen to get it hearing be done.
In this
My lord,
situation,
my application may be considered. If it is found to be incorrect, they can reject my application. They kept on pending my application and without any hearing.
you are denying the existence of that Jaya Prakash. Let that be on affidavit. Within 2 days.
My lord, I need to get an instruction. Okay, my lord. Within 2 days.
Let the matter appear on today's Tuesday. 10th of January. The learned counsel represent at the time of hearing, during the course of hearing, the learned counsel representing the petitioner submits that she does not know Jaya Prakash. In whose name the respondents in their affidavit in opposition have stated that an electric meter has already been installed in the RCC building bearing the consumer number capital H by 1/2295. Full stop.
During the course of hearing, the learned counsel representing the person submit that he does not know Jaya Prakash,
JAYA.
Jaya Prakash, in whose name the respondent in their affidavit of opposition have stated that electrical meter.
That an electrical meter.
That electrical meter.
An electrical meter.
Electrical meter has already been installed.
Is already installed.
Already installed.
In the RCC building.
Installed
In
the RCC building
bearing
the consumer number
H1, H1, capital H1, oblique 2295.
95.
Full stop. Paragraph. Considering the submission of the learned counsel, let the fact be stated on affidavit. In such circumstance, let an affidavit in reply be filed on behalf of the petitioner. Full stop. Let the matter appear on 10th of January 2025. Full stop. The affidavit in reply shall be filed in the meantime, and copy be served upon the learned counsel representing the respondents in advance.
Oblige.
Yes, for the repetition. So, my brother,
Where is it?
Basic extension of time to file report.
কি হয়েছে? কি হয়েছে? কি? What is saying? He's saying to release. কেন? এখানে টাইপ করছেন তো করুন এখানে করুন
Let's say item number 26 and 27 are similar in there.
26 and 27.
In 27, we have filed the report. In 26, we have received the read petition today only, so we will.
it's
file the
already
report on
served,
the
but he want another copy right now had given. Let them file a report, my lord, I'll use my
next.
objection.
I was also already direction to file report. by
I'll
the
use my reply. For 27, he had given me a copy of the report. I'll use my reply to that. And for this, he had, he needs a repetition.
It is appearing for the first time. No.
No, my
No,
lord.
madam. That's it.
November 18, 2024.
Yes.
Thereafter December 5, 2024. Thereafter 11 December
There are
2024.
series of 6 cases. Only this.
We,
serial number
learned counsel. We are not concerned with the other cases. We are concerned, let us direct ourselves to the WPA 645 of 2024. So why haven't you received the copy till date?
No,
No.
no, he had appeared already. my
So
lord.
let
So
them file the affidavit of service that I have received.
their appearance, the appearance is there, my lord.
I appeared,
If you-
I sought the copy of the read
No.
petition, they have served today only.
No, my lord. This is the first time. At served.
1 minute. Let me go through whether there is submission to this effect or not. You had appeared on 11th of December. Let a report by the respondent number 2 be prepared and served upon the learned advocate for the respective parties within a fortnight from date. Learned counsel, your submission should be fair. It is not fair. What you have submitted today, it is not fair. It is not your submission is not fair. If you had not received earlier, then you ought to have submitted on that very date. You have not submitted so. It is mentioned in the order sheet that let a report by the respondent number 2 be prepared and served upon the learned advocate.
True.
So that means that you have already received prior to December 11.
Next case. State matter is there. I will file, I seek a time to file report.
How many
Next
days?
week.
How many
1 week.
days?
Next week I will file, Monday.
Monday.
I'll use my reply. my lord.
That means
No, because there are new documents. There are new documents. Because yet right now we had given for the another, the item number 27.
Not concerned with the another matter. We are concerned with this one only.
If there is a new documents, then I'll use my reply, my lord. If not, if there is no,
If we cannot assume at this stage, can we?
let reply maybe, grant me a reply to file.
Let them file the report. Hmm. Nin. Mr. Bakshi. নামটা কি জানি? মোবিল নাকি? ওনার নাম? মোবিল। ওটা নিয়েছিল না? ওটা
Two.
my lord, I had served a fresh copy writ petition to my brother today. Once again, as per his request. No, no, my lord.
Yes. Presume that it has been served. It is presumed that it has been served earlier.
The contestant might be in the forest department. Subject land is under the forest. Forest system. Actually, these matters, my lord, they are the forest encroachers and the matters are still pending before the Honorable Supreme Court. my lord. Other similar matters are before the court number one.
Under consideration is in my lord. Two matters are there, we listed today. We listed and sent to them. I pray.
Let this
We
matter be
delisted
here.
and- We have to make
Just to mention there.
My lord. My lord.
Same identical.
Same matter. In this, we have filed the report. Oh, identical. Identical matter, let it be not today.
May I please, my lord, in this matter, I lead by my senior, Mr. Surajit Samanto. There is a direction to file affidavit in opposition by 3 weeks.
But the last circuit, the Lord was pleased to direct us to file affidavit opposition. But I'll just pray for next week, Lord, because we received the paralysis. Let it be on next Tuesday, Lord, in the meantime, we will file affidavit.
Seeks extension of time to file affidavit in opposition. Full stop. Let the matter appear on 13th. 13th. Let the matter appear on 14th. The affidavit, copy of the affidavit in reply, the, yes, advanced copy. On 13th itself.
I present the respondent authorities. We have filed our oppositions. We are signing the copy.
Your lordship, in this matter, Mr. V.K. Bishwas is appearing for the petition.
You're filing the affidavit in opposition.
Yeah, we have filed, we have served with serving the copy.
Affidavit in opposition has been filed in the department.
Yes.
I was digging into the affidavit.
Two one.
Mr. Bakshi has the affidavit in opposition.
That is the affidavit.
This one is affidavit in opposition.
Your lordship, I pray for 2 weeks' time for filing reply, your lordship.
Item number 29. Affidavit in opposition has been filed on behalf of the respondents. Let the affidavit in opposition be kept to the record. Full stop. Paragraph. Learned advocate representing, you are the advocate on record.
No, your lordship.
Representing the petitioner seeks fortnight to file affidavit in reply. Let the matter appear before the next circuit bench.
Deeply obliged.
As per the convenience of the similar as which is prevalent here. That is. Nobody is on behalf of the appellant. None is representing the appellant. Let the matter appear on 8/1 tomorrow.
Lord, I am for the petitioner. Service was not completed against the respondent number 2, private respondent.
Not completed.
I dispatched, I had to receive the track report, my lord. Track report is not showing. It may be fixed on Monday, my lord.
The learned counsel representing the petitioner submits that service has not yet been completed in respect of the private respondent, that is the respondent number 2. In such circumstance, the learned counsel seeks an accommodation for this week. Let the matter appear on Monday.
I am deeply
13th.
obliged.
The respondent number 1 is being represented. Yes. Okay. It is, this one was taken up by the bench number 1.
Maybe taken up tomorrow. They're not taken lunch also.
Let us, can we continue up to 34?
Yes.
34?
Yes.
32, WPS 692 of 124. 32 and 32. That's not today.
Not today.
33, I am appearing for the private respondent.
One by one. 32. You are representing the petitioner.
Your Lordship, Mr. Adarsh Shidango is appearing for the petitioner.
Now,
Yes.
at this present
Yes,
juncture, you are representing the petitioner, 32.
Yes, Your
So petitioner is being represented and the you are representing all the respondents in 32, item number 32.
Yes.
All the respondents are also being represented. Yes, now. The learned counsel representing the respondents seeks an accommodation for this day. Let the matter appear on tomorrow date is 8.
Obliged.
But I am appearing for private respondent. Maybe taken up tomorrow.
33. And you are representing? No, the respondent number?
All the response except the private.
Who is the petitioner? You are representing the petitioners. You are representing 4 and 5. Who is representing 4 and 5? Private respondents. You are representing 1, 2, and 3. 1, 2, and 3. Your prayer.
On last occasion, the municipal learned council for the municipal public prayed for time to seek instruction from the department, from the municipal council.
Short from behalf of the learner advocate representing the private respondent. On the earlier occasion, private respondent had.
No, my lord.
In addition to that, the learned advocate representing the municipal council takes time to take instruction in the matter. Let written instruction be obtained. Learned counsel written instruction.
Let there be a direction for affidavit because there are some things are there, lot of things are there in the matter. Already, this honorable court directed for demolition of this illegal structure. By suppressing that fact, we filed this petition.
So what prevented you from making this prayer during the earlier circuit bench?
No, I do not know, I just received notice.
So because on last circuit, this matter came out on the last date of the next, on the last circuit. Now we both does not have the brief at that point of time.
So we'll file our affidavit, madam. It's
Affidavit in
better.
opposition.
Yes, madam, that is better.
How many days?
2 weeks, madam.
The learned councils representing the administration and the private respondent submits that they intend to file affidavit in opposition, and in this regard seeks 2 weeks time or fortnight, 6 fortnight. Let the matter appear in the next circuit bench.
WPA 714 of 2024. But it's 4:15. You all are exhausted. No.
In item number 34, you have to file pay for respondent.
Hmm?
I pay for the respondent.
My senior applies for the petitioners. Yes.
Now what you are praying for?
Paying for an extension to file affidavit. I didn't say it's 3-4 days time.
Item number 34. The learned counsel. Respondent number 1
Number 1,
in person.
he appeared in person because an unlisted motion was moved by the other side and he was served copy half an hour before the matter was taken up.
Now
On the last day of circuit. So now he has engaged me.
you have filed wakalatnama.
I filed it. Before the registry, I filed.
Learned counsel, this should not be the submission. I think I have filed. This should not be the submission. Whether I have filed or I have not filed. You haven't filed.
I'll file right now. I'll file it. I'll just file it.
Learned advocate submits that he is going to file the wakalatnama during the course of this day. Full stop. She further submits that on behalf of the respondent, affidavit in opposition is to be filed, and for that reason, how many days, learned counsel?
1 week.
A week's time is required. Let the matter appear on 14th.